take this on. Let's go through this checklist. What's your understanding of the checklist? Anybody?
Hi, I could do it.
Who's that?
Danielle.
Hi, Danielle. Okay.
Hey.
Let's go, girl. Take it
So
over.
I start with a heading for admissibility and then discuss if it's California law or federal rules of evidence governing.
Okay.
Then I head into logical relevance.
Okay, always discuss for every item of evidence?
Always.
Good.
And then head into legal relevance.
Always discuss?
For California, yes, always.
Good.
For California, go into Prop 8 instead.
Only if what? When would you go into Prop 8?
Only if it's a California criminal case.
Great, good job. Okay.
Then we go into public policy exclusions for otherwise relevant evidence.
Okay, so this is a consideration category, right?
Yes.
So what kind of facts are we looking for to know that the admissibility of that item, that these issues would be relevant to that? What kind of facts?
So we're looking for some kind of maybe an accident, maybe products liability, something of subsequent remedial measures. They made an offer or a statement with an offer to settle, or with medical bills, guilty plea, and in California.
Okay, so do you know about how
expression.
many? Good. Sorry, I'm going to keep cutting you off, so I apologize in advance.
Yeah.
Okay, do you know about how many public policy issues there are here?
There are 6.
Great, I love that. So assigning numbers to the checklist is a really good exercise. Okay, so we have, can you list them for me, as many as you know? If all?
Subsequent remedial measures, settlement offers,
okay, hold on,
medical bills.
Sorry, just go a little slower for me. Okay, settlement offers.
Medical bills. Liability.
Payments or offers to pay medical expenses?
Yes.
Okay. All good. You got the gist. Offers to pay. Okay.
Liability insurance.
Good. Okay.
Withdrawal of guilty pleas. And in California, only expressions of sympathy.
Are you doing this from memory?
Yeah, I did it just before class.
I'm so impressed. Who's impressed? We're
Thank
impressed,
you.
right? Good job. Good job. Let's give it up. Okay. Now where do we go?
Then we jump into reliability.
Oh, sorry. Let me back it up a little bit. So far we have logical and legal always, right? Now the first item, we're going to give full-blown rules for logical and legal relevance. And then subsequently, for subsequent items, we will short form, right? And give just the analysis and the conclusion, correct? Yes.
Yes.
Okay, good. All right, so that's only there. Okay, so where do we go next?
So we jump into reliability. We always want to go into that. A lot of applicants miss that.
Fantastic. Why could you stop there in your answer?
Yeah.
Okay.
Yeah, if you decide that like the lay witness doesn't have personal knowledge, or the expert's testimonies and they don't have the set of basis for what they're saying, or they're not somewhat qualified, or it's not authenticated, you can stop there. You don't even need to go into hearsay because it'll be excluded for non-reliability.
Well, hearsay is not always relevant, right?
Right.
And so a lot of times with evidence essays, when I see the answers coming back, the heading is hearsay right away, or character evidence. And so there's all these foundational requirements that have a lot of points associated with them. All right. So Danielle's doing an amazing job telling us why reliability is so important. You have to authenticate the item of evidence, whether it be a voice, a document, a personal knowledge lay witness testimony. And so there have been times on the exam, usually they're the latter calls, they're not the beginning calls, where a witness is trying to testify as to a fight, let's say, that broke out at a bar, and they were not there, therefore they do not have personal knowledge. So your gut instinct may say, wait, am I really done here? Am I done at the reliability phase? You definitely can be, okay? So with anything regarding issue spotting, if you feel like you're pushing it and it's not organic, it's not authentic, you're probably going into non-issues, all right? I brought this up with a student yesterday I was tutoring. With non-issues, the standards, this is the protocol. You bring it up. So let's say you're on the exam and you're just not sure. You're like, I think this is, I'm not sure. Hopefully by the time you do as much issue spotting, I'm going to recommend that you do, you'll have a very good idea of scope there, okay? But you probably will hit an issue that you're not 100% sure if it is at issue. I want you to put it down. I want you to give a little rule for it, analyze it, and conclude within a couple minutes or a minute or so. But I don't want you to go into a whole huge section on it, okay? It's probably not a major issue. All right, so reliability, we've got personal knowledge. What are the key reliability sections?
So I split it up between oral testimony and written evidence. Within oral, there's personal knowledge for a lay witness and expert opinion, expert testimony. And then within written, there's authentication.
How many parts of the expert testimony test is there?
That's a good question.
Five requirements.
Five.
Okay. Of course, we have two main tests, but I'm talking about the federal test, okay? Actually, you know what? No, it's 5 for both. So really the key distinction with the expert witness rule is regarding element number 5 with Daubert versus Kelly, okay? All the other elements are the same. So it's element 5 regarding reliable principles. So there's a 5-part test. So if you have an expert witness issue, and you have an expert, obviously, then you've got to go into IRACs of the 5 parts. Do not combine them all together. You should IRAC them out. Okay, so we have expert testimony, 5 subparts. This is a key federal versus California distinction. Okay, I would even go element 5. Okay, where else do we have reliability that comes up a lot?
We have authentication of documents, recordings.
So the main one is
voice
of a voice.
authentication.
Yeah, voice is big. I would even just do voice. Voice recording is kind of the same thing. We also have documents. So secondary best evidence rule, right? Secondary California, best evidence federal. All right. Where else? Where do we go from there?
I went into character.
Great.
After that. First.
So the general rule is is what? With character.
It's generally inadmissible to prove conduct.
Okay. And then sub issues under character.
Sub issue civil case. So there are certain rules in civil cases, and then another one criminal. And then under criminal, there is the victim to prove conduct, the defendant to prove conduct,
Okay.
Rape shield statutes, and then specific acts and mimic particularly.
Good.
Shana, I have a quick question. This is Martel.
Yeah.
One, reliability is the best evidence rule. Is that for the documents or?
Correct. Correct. So you need an original. If you have a copy, then that's where that comes in.
Okay.
Under federal, it's the best evidence rule. In California, it's secondary evidence. Okay, it's referred to as that.
All right.
So yeah. All right, character, good. Specific acts, mimic. So 1, 2, 3, 4, 5, 6. 6 sub issues under main sub issues. Good. So far, everything we've gone into is covered within the approach. Okay. I will point out, well, what are the main areas not that I say in the evidence video? Hearsay and the objections. Hearsay you need to cross-reference. And we have fantastic materials, or I like to think so. The students usually love them. Hopefully you're liking them. With evidence, you have the supplement block, which is a whole supplement to give you additional cushion on these areas so you can reference them. But for structure purposes and memorization, you really should go straight to the approach cross-referencing with the long outline for hearsay, exceptions and exemptions, as well as the objections. Maybe a few other areas that I'll point out in a moment. Okay, so when I made this years ago, and I've edited it a couple times since, I tried to really condense as much as possible for the approach to be like, okay, at the end of the day, this is what you could memorize with hearsay in the long outline and be fine with evidence, okay? So that's something to keep in mind. All right, Danielle, you're doing so wonderful. You want to keep it going with impeachment?
Sure.
Okay, great. So how many areas do we have here? How many subcategories? And who are we impeaching? Who are we impeaching?
Here we're impeaching a witness.
Good. Okay. Or the credibility of a statement that's coming.
Hearsay, a hearsay declarant too.
Okay. So for
we could do it with a prior inconsistent statement of the witness testifying. You could do a prior felony conviction, a prior misdemeanor conviction.
Sorry, you're fast.
The coffee's kicked in.
Oh my gosh, I know that feeling. I gotta cut back. Okay. And
then misdemeanors or misconduct that you haven't been convicted for that bear on truthfulness.
And that's usually towards what? California, right?
What is that?
Those are usually rules that are heavily California tested, right?
Maybe.
Okay. It comes up a lot with truthfulness. So with the call of the question, they're going to have to say answer according to California law, right? We haven't hit civil procedure yet, but they tested California civil procedure for the first time in, I believe it was July 19. Okay, July 19. I'm pretty sure that's the year. Yeah. When they tested that area, and we'll look at that essay when we talk about Civ Pro next week, they did not in the prompt say answer according to California law. So it was the first time, I believe it was just a typo. They always do, but sometimes I think it was a typo. So applicants applied the federal rules in many instances, the repeaters that came in that bar. So I want you to always, when you're dealing with evidence or civil procedure, I want you to look, if they don't say what body of law to apply, federal or California, I want you to look at the facts on the court that the case is active in or has been filed in to determine what body of law you are to apply, okay? Hopefully that does not happen, but in that event, do not just go federal, because in that instance in Civ Pro, if you looked up, you would see that the last court that the case was filed in, or the first court, was California State Court. And therefore you are in a California, civil procedure question. So, you will revert obviously to the federal rules if there's no California distinction, right? But it's just an important thing to know. Okay. All right. So impeachment, 1, 2, 3, 4. So 4 main areas here, 4 main areas. Character, we said 6. Okay. And then we also said with public policy. Who wants me to send them this document? It's actually kind of pretty. I like it. Okay, I'll do that. I'll do that later. All right, let's keep going. Where do we go from here?
Okay, we jump into privileges. Starting with marital, there are 2 types of marital privileges.
Okay. Do you always go into both?
I think so, yes.
Even if just to negate one, right?
Yes.
Okay, I actually want you all, don't like how I did this in the approach. Okay, go to, actually, I'm gonna, here we go. Here we go. Okay, so we're gonna do the spouse like this. Let's set it up like this. Okay, spouse testimonial. A spouse may not be called to testify by the prosecution against their spouse on trial in a criminal case, nor can the spouse be compelled to testify against the other spouse in any criminal proceeding, even if the spouse is not the defendant in the case. For example, in a grand jury proceeding. Note, the privilege belongs to the testifying spouse. Thus, he or she can choose to testify, but cannot be compelled to do so. The key is there must be a valid marriage. The privilege ends at divorce, okay? I like the way that the long outline lays this out better than the approach, okay? So reference, I'm looking at probably an old volume, but it's in the privilege section in the long outline, okay? The next is the
next will be, we went over both of them. Oh yeah, confidential communication,
okay. I'll bring it.
followed by attorney-client. And physician-patient, as well as psychotherapist-patient. And there's a California distinction with those.
Wait, what did you say after attorney-client?
Physician-patient and psychotherapist-patient, and there's a California distinction there.
Right, okay. I'm just trying to make sure it's all through. Okay, good. Okay, those are the main ones that you need to know. All right. These are obviously only at issue, right? So just to back it up, public, so far, just let's kind of go through it. Logical, always. Legal, always. Public policy, how many? Let's all just say it out loud. 6, right? 6 main ones. Like Danielle said, we're looking for car accidents. We're looking for subsequent remedial measures. There was an accident and they fixed something, okay? I promise I will pay for the damage for the hitting of your car, right? Proof and offers to pay medical expenses. Then you always have to authenticate. You have to make the item of evidence reliability, okay? So we have personal knowledge, expert, and the authentication rules, better known as best evidence, federal. Now, you're not going to do this on the exam, by the way, okay? I'm going to show you what you're going to do on the exam day if evidence comes up, all right? This is a very thorough checklist. And this is indicative of the checklist that I want you to be making when I say write out checklist. This is how thorough, when I say a regurgitation of the approach, this is what I'm talking about, okay? Sitting with it and coming up with your structure. Okay. So then we go into, is this character? What are we looking at? The character of whom? Either the victim in a criminal case or the defendant. Impeachment is of the witness or a prior testimony, maybe in a deposition. Privileges, we have the spousal ones, 2 main ones, obviously 2 of them, attorney-client and physician-patient. This is also maybe. You could be done at privileges, you could be done at character, you could be done at impeachment, right? Not everything is hearsay. You see how much we could have before we even get to hearsay. Okay, so let's come up with, because I know this will help you. Let's come up with a little checklist for hearsay here. All right, so we have, let's see, how do I want to do this? Okay, 1, not hearsay. two items that are not hearsay. What are they? Independent legal significance. Based on what the evidence allegedly proves is not hearsay, offered to prove a defendant said the words, not to prove the content or truth of the words. Okay, just that the defendant said those words. That is my land in an adverse possession case. I'm giving you this car as a gift in a dispute over ownership. Okay, so just that the actual defendant said those words. Offered to show the effect on the listener, that comes up. Offered to show the speaker or writer's knowledge. A statement that goes towards a circumstantial state of mind, that does not come up heavily. Okay, then we have exceptions. I'm just going to make independent legal significance the main one there. Okay. Let's just come up with a quick list here. Danielle, do you want to throw some at us, or I can just go through it?
Yeah, I can throw them.
I'll start. Admissions of party opponent is extremely tested, comes up on almost every single evidence essay, some form of admission. You should know all the different types of admissions. You should know, and they're all, you do need the long outline for this, okay? So we have just a straight admission. We also have, I'll tell you the ones to know, adoptive admissions. A party may make an admission by expressly or impliedly adopting or acquiescing in the statement of another person. If a silence, if a reason, you should know this, if a reasonable person would have responded and the party remains silent in the face of the accusatory statement, it may be considered an implied admission. You should know vicarious admissions. That comes up on the essays as well.
Shana, quick question. Aren't these exemptions?
Yes. Wait, hold on. Why do I, no, they're exceptions.
Oh, because our long outline states these as exemptions to the
Hold on a
hearsay.
second.
Yeah.
Oh, I know what this is. This is a very old volume I'm looking at where we just clumped them all together. I see what you're saying. Okay. Yeah, so this is an exemption. But on the exam, you do not need to label it as such, okay? You can just put the heading.
Okay.
Okay,
I
good.
think,
Sorry.
is it
Wait.
like the exemptions are admissible because they're not hearsay? So one of them, for example, like you said, is the independent legal significance effect on the hearer. And I think admission by party opponent
It's an exception.
is also, oh, I
It's
thought
an
it was
exception.
admissible as
No,
non-hearsay.
you're good. This is an exception.
Okay.
Okay. So, because these are where, hold on a second. Yeah, the other ones were not hearsay. These are the exceptions. Okay.
Okay.
All right. So
Do
vicarious.
you recommend separating the hearsay exceptions between like requiring unavailability and not mattering if the witness is unavailable, or the
No, I
declarant?
would recommend having it as one long checklist.
Okay.
That's what I'm trying, that's what we're doing here. I don't want to like confuse everyone with the semantics of it. So I would prefer you just have one long checklist and you spot them as either hearsay or non-hearsay. Okay. All right. So then we have the admissions, all of the different admissions, as well as prior inconsistent statement. Okay. We have former testimony. Yeah, I'm just putting them all together because these are the ones now where the declarant is presently unavailable. But you could make a little
Mhm.
note for it But it's just easier to do it as one. Okay,
Dying declaration.
big one. Comes up a lot. Statements against interest, I said. Okay, I'm not so worried. Don't worry too much about statements offered against a party who procures the declarant's unavailability. It's never been tested. Okay, you don't need to worry about that. You also
Okay.
don't need to worry about statements of personal or family history. That's never been tested either. Okay.
Okay, then you have present sense.
Present state of mind. Present sense of expression.
Yeah.
Yeah.
Excited utterance. Past physical condition for mental diagnosis or treatment.
All of these come up equally, by the way. And if you're in a pure evidence essay, you're looking at, well, regardless, let's say every time hearsay comes up, you're looking for at least 2 to 3 exceptions. 2 to 3. You'll never
Okay.
just have one.
And then there's some document ones like ancient documents, recorded
I wouldn't worry too much about
Oh.
ancient documents. Worry about business records. Worry about public records.
recorded
ancient, maybe.
recollection.
And by the way, when I say don't worry, I'm talking about the essays. You may have a few questions on the minor nuances on the MBE. So you should know those for the MBE.
Mhm.
I talked about declarations of then existing physical or mental conditions. Oh, judgment of previous convictions. Okay, those are the main ones to know. So it's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Okay. Now a few sub issues. Great job, Danielle. Thank you. A few sub issues. I want you to know the confrontation clause. And I want you to know what judicial notice is. And I want you to know what the objections are to evidence. Okay, so that is your main checklist. Everybody should either copy this down or have it. Let's do a practice now and tie it all in, okay? It's a lengthy practice. It's a challenging one in my opinion, and it's a recently tested essay. So if you get a pure evidence question, or even if you get a cross, you will see it in this format. This is how they test the evidence area on the exam or evidence. Okay, so let me open up the essay. I'm gonna save this first. You guys, raise of hands who wants me to send this to them? Okay.
Yeah, I need it.
Okay, I should do that. You know, my goal is to do these for every single approach. That's the next thing I'll be doing. I'll add it to my long laundry list of to do. Okay, save that so I can send it now. Usually I don't save them. So let's do a practice, shall we? Yes? Oh, actually, wait, no, I have a few more things I wanted to say about, just kidding, a few more things I wanted to say here. Know the approach well. Evidence essays are typically racehorse questions. When I say a racehorse, especially a pure evidence, you're on the lookout for a minimum of 20 to 25, 30 IRACs, 30 issues. If you're in a pure evidence essay, when I mean, everyone knows what I mean when I say pure, right? Pure meaning no crossover. It's just evidence. And you have 10 IRACs, you're missing something. You're missing an abundance of issues. The goal on an evidence essay, very important, is not to have long drawn out analysis. The key is to complete the IRACs and finish the essay. So if it's between, oh, I want to say more, I want to give a counter, don't do it. You're going to run into trouble with timing. So what I would do is when you issue spot today, before, for those of you that have not written yet, which I think is the majority of you, count up the amount of issues you have, divided into the remaining time. I know I'm telling you to write, you know, within, you can go outside the scope, but divide it and try to keep within that time frame. Try to keep within that time frame, meaning it might be 2 minutes in IRAC. If you have 50 minutes left and you have 20 IRACs to go into, or 25, it's less than even 2 minutes, okay? Potentially per IRAC. So you've got to literally go 11:27. I'm hitting the first heading. By 11:29, I am out of here. It's got to be that disciplined. That's how you're going to work on your timing with this. So that's something to keep in mind. So no more typically than 2 minutes on an IRAC on a pure evidence essay. If you have a crossover and it's like 2 admissibility calls, you can spend a little bit more time on the scope of your analysis. The key again is to complete the essay. I would recommend that everybody practices at some point before the exam at least 1 to 2 evidence essays closed book after you've done your preliminary practice to make sure that you hit your timing. Writing closed book essays is stamina building. It's not about having the rules down. You can make up like a good commonsensical rule, okay, a variation of it, but it's to get that 1 hour complete, all right? I know some of you, I hope, I'm just saying, some of you are looking a little tired, and that's okay. And that's so rude to say someone looks tired. I hate when someone says that to me. So I'm not calling out anybody, all right? And I probably look tired too. But my point is, take breaks, be good to yourself. This is the turning point, okay? It really is. It's the turning point. Next week is the major turning point as we start heading into some non-MBE subjects and then adding time to the schedule to start our re-review. So a subject like evidence, we can cut some, I'm getting some private messages of like, yeah, I'm beat. Okay, I know, I've been there. By the way, I remember when I took the bar, and I say this story every single bar, I was literally, I was like, about to take a shower or whatever. I know TMI, but I'm just saying, like, I was really exhausted, and I was like sitting there or standing, whatever. They're going, I'm blushing, going, I'm done with this. I'm not memorizing evidence. This is crazy. Why are they making me memorize all of this stuff? And I really don't want to keep going, and I wanted to give up. I had a 6-month-old, right? Violins are playing, but I did. It was very challenging. And I always kept it going. And I had a mantra in my mind that maybe will help you too. And not to digress from what we're doing here with evidence, but I think it's really important, right? That state of mind that we started the classes with. The perseverance mantra, let's bring it back in, all right? Because my mantra was, I'm never doing this again. It wasn't that fancy, but it literally was like, I'm not doing this again. Like, I need to make money for my family. I didn't think I was going to be a bar tutor, which I'm so happy I did. But I just knew that I was never going to do this test again, okay? So let's all just take a quick stretch, all right? And sit up tall and be like, let's attack this practice, all right? And let's really get in our zone and make sure that we're not going to do this again. Who's with me today? Everybody's with me? Okay. All right, let's do this. I'm loving the messages coming in. Funniest thing I've ever seen. Okay. All right, let's go. So our practice today, let me share it with you all since I know you can't wait for it. And you may have seen this essay. I have not assigned it, but you may have seen it. You may have taken this bar. No matter what, it's good practice. Do your best with it. We're going, thumbs up if you see it, please. Okay, we're going to spend, let's issue spot this in 10 minutes. You can use the checklist. I wish I could keep that open too. There might be a way, I'm not figuring it out right now. But if you took a screenshot of the checklist, you can use that. Let's issue spot well. Let's be thorough, and please keep attention to the issues that you should always go into and the issues that you should merely consider. Okay, it's 11:32. Let's take 10 minutes and begin, please. Good luck. And you should issue spot on the computer.
What year is this, by the way?
This is Feb 2016.
Thank you.
It's page 96 in volume 3. Good luck. I'm gonna mute everybody. 3 more minutes. Start wrapping it up. A couple minutes, I'll give you. One more minute. Okay. How'd it go? Okay, let's see. Level 1 to 5, 5 being the hardest. What are we at here, you think? A 4? Okay. I agree. I think it's a long essay and I think the structure is a little confusing. So let's do our best with it. Let's take it step by step. So I'll start here.
Shana, this might be a dumb question, but do they always say it's gonna be California or federal?
I
Did you ever? Yeah,
I
I'm sorry.
just talked about that. So I'll
Sorry.
reiterate, they will typically say it. But if they don't, you're gonna look to the facts for the clue. You're gonna look to see what court you're in, okay? But yes, in evidence, they've almost always said it. I have not seen an evidence example where they did not put it. Okay, sometimes in civil procedure, as I said, they have one time when they first tested California, they did not put it. So you had to know what court the complaint was filed in. Okay, so
Shana,
first let's
sorry,
start.
Shana?
Yeah,
One more question. So is there ever, this is Lillian, is there ever a time when we have to, they will tell us to raise the different distinctions between
No.
federal and California? Okay,
no, they have never done
so
that.
never in the same essay. Okay,
No, thankfully.
okay,
no.
thank you.
Yeah, that would be, I think that would be very difficult to do. Okay, and also it wouldn't really make sense, right? It's one or the other. So, you could default to the federal rules if California does not have one, right? Or there's no distinction, then it is the federal rule that it defaults to. Okay, so I'm gonna begin. I'll scroll down a little. So what do we have going on here? I mapped out some parties. We have Mike as the president, Supervisor S2. We have Pam, David, Ed, a lot of parties. Maybe somewhere on top you could have just mapped out, identified who everybody was, just for reference purposes, if you felt the need to do that. So anyone want to take on call one? Anybody? You know what has to be discussed right off the bat.
Okay.
Why don't we all do it together? Well, I don't know. Let's see how that goes. Okay. What's our first heading always?
Admissibility.
I did that already.
Okay. Oh, you did.
Logical.
A logical relevance.
Okay, Marta, are you going to take on call one?
Might as well.
Thank you. You get a star for participation. Okay, logical relevance. Let's go. What happens here? Is this logically relevant?
The email, yes, it's a material fact of the case that that is trying to be proved for the matter.
I like that you said that, a material fact in the case, because in California, what is that little blurb there in the rule? The fact must also be in dispute,
Dispute.
right? So we have the email, it's the basis of the lawsuit. So yes, it's logically relevant. Okay. Legal relevance. Are we weighing any factors here?
I said that it was.
Let's look at the email. A week later, David circulated the following email. I just thought you should know that Pam was fired because she is a thief. She caught her stealing money. Sue caught her stealing money from the petty cash drawer after Pam's affair with Mike ended. Do you think we need to weigh the prejudicial effect of that? Balance it out with the probative value?
I really didn't think so because it's just so material. It's a material fact in the case that I feel that that needs to be
What's the basis of the lawsuit?
Defamation.
Defamation.
Right. So it's highly probative, right? To whether or not to whether or not the statement was in fact defamatory. So yes, it's legally relevant. I would do some weighing though, just because of the plain language of the email. But whether or not it supports a case for defamation, yes. So legally relevant. Okay, where do we go there in our checklist? I want to if you could just tell me, where would you go in your mind? Okay, so I've hashed out the relevance. Now where do I go?
Whether the email is reliable evidence.
But before that, just in terms of checklist, you're going public policy? No, there's no public policy issues here, right? Okay, so next you go to reliability. That's correct. Are you making a heading reliability or just going into the standard that's at issue?
I'm making a heading.
Okay, I would make a heading authentication. So what's at issue here?
The admitting the email as evidence.
And what sub issue is under authentication here?
Secondary.
Love it.
Yeah.
Good. Why are you laughing? Why are you laughing? What's funny? Let me in on the joke.
I'm so horrible at evidence that I'm laughing at myself even doing this.
Good. I like that you're laughing because we got to try and make this fun, right? Evidence is one of those areas that can kind of be fun. When you're litigating a case, it definitely is fun because it's always coming in. Okay. So secondary evidence rule, what is the standard here? What's needed?
Is it you need the
The
original?
general rule is we need what? What do we want? We want something authentic. We
Right.
don't, so what is that called? We're dealing with a document, right? So what do we
Right.
want? The
Original.
original, okay? If we don't have the original, then we want at least what?
Some type of copy of it.
Okay, so is there any evidence that this is not an authentic copy of the email? What did they do with it? They printed it,
They're printed.
right? So is the secondary evidence rule met? Has this been authenticated, the email, the printout? What does your
It
gut
didn't.
say?
I mean, it didn't
You're
explicitly
in
say
court,
that.
you're in court, you're the attorney on this case, you present a printed email and authenticated where it was printed from, let's say.
Mhm.
Received the email at work, that he printed it. Is that authentic? Is it, someone chime in, is that
Yes,
authentic?
yes.
Yeah.
Yes. It's a photocopy. So you're looking, if that said like, they changed it, they manipulated it, then we have authentication issues. But we're to assume that the printing is a proper copy of it, okay? So this is met and therefore secondary evidence is met, can come in. Okay. Now where do we go?
This is where it took the turn for me.
Okay, let's go through our checklist. So is it character? Is this character evidence?
No, it's not.
Going
It's not
to-
character. It's not
Okay.
character. It's not
Is it
impeachment.
impeachment? Is there a privilege here?
No,
Is it hearsay?
I didn't think it was. So I concluded that
Yes,
it was. It was.
Well, someone chime in. Is it hearsay?
Oh, it is hearsay.
Whoa.
Yeah.
Let's walk through the standard. Okay, what is
I think
hearsay? Hold on, let's
Hearsay,
hold on. Let's let Martel take it.
No,
What?
they can take it.
Okay, someone else. Who wants to take the hearsay analysis here? Latrice?
I could. Can I
Okay.
try?
Yeah, of course. That's what this is about.
It's an out of court statement because it's an email that was sent to employees from an employer that occurred out of state. Or
Okay.
that occurred out of court.
Out of
But
court.
it's also double hearsay because it's the actual document, which is also out of court, and then the statements within the document is another. It's like two levels of hearsay. You want to talk about both?
Fantastic. But before we get to that, is there any non-hearsay here at issue? Go look at your checklist that we just made, please.
Yeah, there is.
Who's that? Who said that?
Ginger.
Hi, Ginger. What is it?
It's legally significant on its own.
Potentially, right?
Yeah.
Oh, and by the way, during the break, and don't get caught up in the semantics, but the admission and the prior inconsistent statements, those are referred to as exemptions. They act in the same way as exceptions, okay? So I don't want you to get caught up in the labeling of them, okay? If they're at issue, you're just bringing up the standard for them. But they mean the same thing. I don't even know why the evidence code does that. But if it is in fact hearsay, if the item or the statement is hearsay, then it could come in as an exception, as an exemption, which acts exactly as an exception, okay? Just so you know. All right, just for purposes of labeling, but I don't want you getting caught up in that. All right, independent legal significance. Ginger, can you give me the analysis there? Why is this independently legally significant?
In a civil case, defamation is, because the case is about defamation, and that is the statement is showing
It's the defamation, right?
Yeah.
So
Yeah.
onto itself, it has independent legal significance. Onto itself, separated from it being a hearsay statement. Okay,
Shana, I have a question.
yes, who's that?
It's Danielle.
Yes, Danielle.
When you're giving the definition for hearsay, out of court statement offered to prove the truth of the matter, how would you feel about breaking up out of court statement? Yes. offered to prove the truth of a matter, no independent legal significance.
Well, independent legal significance would definitely be its own IRAC. I think that hearsay should be analyzed together within one section. So I don't
So
think
how do you deal?
you
how
just
do
say
you
it's an
deal
out of
with-
court statement bringing up the defamatory language.
So, but to the point where we're saying this is not hearsay because of independent legal significance, we should just address that under legal significance.
Correct. Correct.
Okay.
So you're first establishing it as hearsay under this hearsay heading right here. Okay, that I highlighted. This is your rule for hearsay.
Mhm.
Out of court statement, truth of the matter asserted. Okay. You analyze that it's hearsay and you conclude on that.
But it's not hearsay. Because
Oh,
it's not offered to prove the truth of the matter asserted.
Right.
Well,
That's what I'm thinking.
it's
I'm-
possibly hearsay in this instance. It's possibly hearsay. I agree. I don't think it's a
Oh,
straight-
okay.
I don't think it's a
Okay.
straight shooter, but I think
You could
that-
say this could be hearsay depending on what it's offered to prove. Okay, got it.
Exactly.
Thank you so much.
Yes.
Thank you.
and then you're bringing up any possible way to get it in, and that's how evidence works. You see, so it doesn't always have to be a slam dunk. Like if you ever want to litigate, you'll see that in court, you're literally like, well, Your Honor, it's a public document exception. No, oh, it's a business exception. Nope. Oh, it's an independent legal significance. Yes, right, and then you get it in. So when you're dealing with the section on hearsay, you're trying to determine if it in fact is, it's going to come in on either one of these levels potentially. Okay, so that was, I think, the tricky part here. All right, so it does have an independent legal significance. Now, if it is in fact hearsay, then it's double hearsay, as I think Ginger pointed out. Good job. And what do we need for double hearsay? What do we need? How do we set this up? Pursuant to the approach. Ginger, do you want to take this on?
I can try.
Okay.
You would say level 1.
Yes, level 1, like Mario Brothers. Level 1.
And that's the writing itself, the
That's
email.
the email. Okay, and so every level needs to be under an exception, right? Every
Right.
level. Okay. So what's the exception here potentially?
That, I mean, for me, the exception is the independent legal significance, but I
But
don't
that's not
know.
an exception.
Right, that's
right. That's not an
non-hearsay.
exception. So that does not apply to double hearsay. And by the
So
way,
I
if
was-
you didn't
Business
hit,
document?
hold on a second. If you didn't hit this independent legal significance, this is maybe a 3-point issue. It's not a major issue. Okay. It's just a little wrinkle that this could come in as independent legal significance. Okay. But the main one here is this double hearsay. Level 1 email.
I would say talk about business records or
That's correct.
recorded
Business
recollection.
Business record. Okay. Is it a business record? There's a 4-part test. Which part of the test is met and which part is not? Let's look at the standard. What do you need? You need a,
Record of the event.
okay, so do we have a record of
kept
the event?
in-
Hold on, slow down. Do we need a record of the event? I mean, do we have a record of the event? Yes.
Yes.
What else?
Kept in the regular course of business.
Okay, is this in the regular course of business?
That would depend. You can
What do the
write
facts
some
say?
analysis. I mean, he sent the email. I don't know if he always sends those types of emails, so.
Do you think that he sends those types of, that's a standard business practice to send an email like that?
No.
No,
No.
it's definitely not. So this element is not met. So there used to be a thing that I would do when I taught live, and the class feels like literally 10 years ago. Feels like that. It feels like that much has happened so far for me, at least personally. But when the class would go, and sometimes I'd have a jam before the internet got very busy, and I was doing this in the early, I don't know, maybe 2012, 2013 period, still 2011. And I would say, is this met? And everyone would go, yes. The inclination is to meet something. I want you to try and stop and say, what is the standard? And then go to the facts, because I'm looking at a lot of your analyses coming in on your writing, and a lot of you are doing that, where it's like, yes, this is met, but the analysis is not on point. So you have to be able to have the proper analysis. What does that mean? It's taking the key parts of the rule, connecting it to relevant facts, and making a legal assertion pursuant to those facts as to whether or not the issue, the heading, has been met. So you got to be careful, all right? Because I did see when I said, was this in the regular course of business? A lot of you went, it is. And so it's okay if you get stuff like that wrong. Remember, inevitably, you want to complete the essay. And in evidence, I mean, if you get consistently your conclusions wrong, you're not going to pass the essay, okay? So analysis is not always so important, meaning like if your analysis is shaky and you're just storytelling and just giving facts, then, and you're not weaving in the standard, that's what an analysis is, you can get partial credit. But if you're just wrong on what you're concluding, they are looking for specific conclusions, as I've told you, they have to be, right? Especially in evidence. It's really, there's no murky waters in evidence, okay? So it's very important that you go back to facts when you misanalyze them and you understand, was it the law that I didn't get there? Is there a particular standard I'm not understanding? Or do you not understand that a certain set of facts would incite a certain legal standard, okay? Because that's how the scope of your issue spotting will inevitably expand, okay? Yes, Chris?
So why would it be a multiple hearsay? Because the statement itself was just the email. He doesn't say Sue told me she was stealing money. He just says Sue caught her stealing. So I mean, what would the second statement be?
Ginger, what would you say to that?
I'm sorry, I was not the one that brought this up. I didn't think of it.
Who brought up double hearsay? Latrice. I don't know why I thought that Ginger. Sorry, Ginger.
I'm so offended. I'm just joking.
Tell me why the second level is at issue.
So it's two things. So it's the actual physical document versus the words in the email, right? So the document is one level. Second level is whatever the statement was.
You have a statement within a document. Whenever you have that scenario, double hearsay is incited.
Okay.
That's how it works. So just accept it as true. Some things we don't have to deeply philosophically understand in the law. Sometimes we just accept it as true and we move on, even though it may not 100% connect. Okay. All right. Let's keep going. So Latrice, then why don't you wrap this up? I apologize for that. I don't know why Ginger must have brought up something else. Okay. So anyhow, we have kept in regular course of business not met, and therefore no level here. Level 2 is what? The statements in the email. And what exception does this incite?
I guess you could say state of mind. Potentially.
What's the standard for state of mind?
I believe it's a description of what's actually being observed at the time being observed.
Or is there any observation taking place?
I guess not.
Okay, anyone else want to say what this exception level could be?
I would say recorded recollection.
I don't see that.
Okay.
Look at your checklist.
Did we say party opponent? Statement of party opponent?
Admission by
Yeah,
party. Yep,
yeah,
that's
yeah.
it. Good. Who was that? Ryan? Who was that?
Yeah, it was Ryan.
Okay, I'm starting to get to know the voices now. So walk me through this, Ryan, please. Who was this a statement against or offered against?
It'd be offered against David.
Right. Okay. So we have admission. So yes, this is a statement being offered against David. Does it suffice as double hearsay, Latrice, at the end of the day?
I would say yes.
Ooh, see what you just did? Take a moment before you say yes, it has to meet both levels of the exceptions, right? Each level has to fit, under at least one exception. So we just said the business record is not met. So
Oh,
therefore,
okay.
right,
It's
it
not-
could
it's not
potentially
correct.
come in as non-hearsay if it's coming in for that purposes, if it's coming in for independent legal significance only, okay? So that would be the conclusion here. Not double hearsay, might come in as independent legal.
Shana, I'm sorry for interrupting you, but I just looked at the model answer and it doesn't even mention multiple hearsay either.
One does, one doesn't.
Okay, so yeah, that's fine.
Yeah. Okay. All right. So one does, one doesn't. And when I do this, I'm extremely thorough. So I bring up what potentially could always be at issue. Not always, but what could be relevant here. Because if one applicant hits the double hearsay, but misses the legal independent significance and vice versa, you still can get your points. Okay. All right. So let's keep going. Sue's testimony. Who wants to take on this one?
I'll try.
What is Sue's testimony? Let's see. Sue says, Sue testified she had caught Pam stealing $300 from petty cash drawer, and that when Sue confronted Pam and accused her of taking the money, Pam simply walked away. It's a lot of drama going on in this fact pattern. David himself testified that the contents of the email were true. Okay, we'll get to David. So let's talk about Sue. Who said they want to take this on?
Ryan did.
Okay, Ryan, let's go.
Relevance, logical.
Good. Okay, is this logically relevant, what Sue said?
Yeah, it's going to a disputed issue in the case.
Good. So short form here, right? We're not going to do a whole rule again, just
Okay. Just
quick
yes.
analysis and conclusion. Okay.
Legal
Next.
relevance. Yes, it passes.
Why? What's the probative value? Whether or not what?
Whether or not she stole the money.
Whether or not she's a thief.
Yeah.
Okay. You think you could give a little counter argument here from Pam?
Oh, from Pam,
Yeah.
because he didn't see her in the act, that it might be unduly prejudicial on the
She's
jury.
arguing that it's false, right?
Yeah.
So I would give a little counter just from, so when applicants ask me, I'm getting 65s, how do I get, or 70s, we don't really go higher than that. The analysis is what can bolster your score. Now, of course, only do that if you have time. Only do that if you have time. All right, keep going. Good job. Where do we go from there?
Reliability.
Right. So we don't have any public policy, right?
Yeah.
I'm giving you the reliability already. Okay. What is the reliability standard?
Personal knowledge.
Right. Now, you might see this as lay witness, by the way. So either heading is fine. Lay witness, personal knowledge. Does Sue have personal knowledge of her communication with Pam?
Yes.
Okay. So quickly in and out here, right?
Mhm.
Okay. Now where do I go?
Here,
Yeah.
I was going to ask if here, thinking about how you asked in legal relevance, is there a counter argument? Would Pam try to bring up that this is inadmissible character?
Well, yes, we're going to get to character, but there's something I want you to do just for organizational purposes. If we're looking at Pam's testimony, she says, and then I have this in my notes. She says,
She confronted her and then Pam walked away.
right. So we have two separate statements
Mhm.
with her testimony, right? So
Yeah.
I would organize it whenever you have two different statements or admissibility standards in a sense, I would organize it per statement. Okay, so 2 different layers of that. So let's start with the first one. And if you didn't know to do that, now you do. That's why we're doing this. Okay, so if you're like, oh, I didn't do it that way, that's okay. That's why we're doing this. All right, so I would have gone A right here, and I would have done like this. And I issue spotted this before class, so I'm just like you all. We're doing it all together. Okay. Character evidence, Pam stealing $300 petty cash. Okay, so we start with the general rule. Ryan, what's the general rule in California?
Generally not allowed.
Okay, so general rule is not admissible unless what?
Ultimate issue.
Good. So in California, if it's an issue in the case, then it could be admissible. And is it? Yes. Walk me through just a little bit of the issue here.
Whether or not she stole the money goes to the defense of truth.
For defamation.
Yeah.
Perfect analysis. Okay, great. So your conclusion here is it's admissible character evidence. I would say something like California evidence is admissible when character is a material issue in the case. Here
When we
we have
talk about, I guess it's testimony on it still comes in, but will we talk about it being a specific act rather than?
So one model goes into that, one doesn't. And so
Okay.
what we're seeing here is the inconsistency of the models. When you hit models, when you're doing issue spotting, where model A has a few more issues or model B, vice versa than the other, what you know is that those are minor issues. So they're not major issues. So it's relative. We have 30 potential IRACs here combining model A and B. So when I do these exercises, I look at both. And of course, the big ticket items is what you want to hit. I would say you could bring it up. You would get at least, I'd say, a couple points for it, but it's not a major consideration. All right, so general is not missable, but I'll go into it because one model does. So if you did, that means your issue spotting is even that more thorough. If you didn't, you still could pass the essay because what the model is telling you is without that in one model, you still pass the essay, you see? So that's where it shows you there's room to miss issues. There's room to miss issues. You want to try to hit as many as possible. All right, but unfortunately the models from California are not always consistent. They're just not. So what I do as a bar tutor is I say, we have to assess the whole picture here. These are the main ones. So characters, obviously, like, okay, so let's weigh it. If you missed character here, but you got this little minor impeachment issue of specific acts, right? Because that's where they went with it. Evidence can come in to impeach, okay, on that specific act. Then if you miss the character, you're not passing this section. Okay, that's the crux here. All right, so we have character. Yes, I'm just abbreviating that. All right. And the conclusion. Okay, next level or next fact.
The Pam walking away or Sue's statement. Yeah, Sue's statement that she took the money. We'll do
Well, that Pam walked away. We already did that.
Okay.
The 300 cash. Yeah. So Sue's statement that Pam walked away. You want to continue? You're doing.
Yeah, sure.
Okay,
Sure.
Perfect.
So hearsay.
Great. This is fantastic issue spotting. Okay. Give me the analysis a little, please, for this being a hearsay statement.
So out of court statement, offer for the truth of the matter asserted, she confronted her about stealing the money and then Pam just walked away from it, which we could talk about whether or not you stole that money is hearsay, or we could focus on her act of walking away as an admission.
Right. Okay. The admission really is where right. So, but it's hearsay because what is it going to? What's the assertion?
That she stole?
Try again. And I think that the assertion is where a lot of lawyers, applicants get a little confused. What's the assertion here? Remember, she walked away. So what is the purpose of the statement? she walked away. Would she have walked away if she
Oh,
wasn't
no, yeah,
guilty?
she would have responded. Yeah, I'm sorry. We're talking
That's
about the
okay.
admission. Yeah, yeah. She would have responded if she hadn't done it. She wouldn't
Right.
have just walked away. Yeah.
Right, she would have said something like, I didn't do that,
Yeah.
right? Okay, so hearsay, yes, admission by party opponent. What kind of admission is this?
An adoptive admission by silence, right?
Good. Okay, so by the way, this is admission by party opponent is the heading. And then you could give a little just rule there and identify it as an adoptive admission by silence. Or an adoptive admission would be fine as well, okay? So here she's accused of stealing, she gives no denial. Is this an adoptive admission pursuant to those facts?
Yeah.
Yeah, she adopted it. So you see how you don't need, I mean, I just said that very curt, but you don't need this long, lengthy analysis and evidence. You just need to make it eloquent, okay?
I have a question.
Yes.
Is if it is an adoptive admission, can we then say that it's the statement against interest, like the pecuniary property and penal interest one as well?
That it goes to her penal interest?
Like it would satisfy that exception because of the theft.
Walk me through it. What's
Right.
your heading?
Additional potential exception.
I think it's a stretch a little. I think we're
Okay.
good with this.
Okay.
Yeah,
Doesn't the statement against interest need to be, the declarant has to be
we're not in
unavailable?
statement against interest.
Oh yeah, declarant has to be. No, that's what I was asking about. She's right.
Oh, I see. Okay. Oh, I see. She's responding to you.
Yeah.
Right, exactly. And that's another big part why it's not relevant. Okay, let's keep going. Good, good, good. I love this. Where do we go from here? What's our conclusion here? That's an adoptive admission, okay?
Yeah, evidence in.
So do we have a part C? Oh, I think this is what you were getting to before. Do we have a part C of the statement?
Would it be the confrontation part? Like what
Yeah.
she said?
We have
Yeah.
to cover everything regarding Sue. We have to cover everything. So, okay, so let's just go back. She says she caught Pam stealing 300. We covered that, right?
Mhm.
She confronts Pam and accuses her of taking the money. Did we cover that?
No.
No. Okay, so let's cover that now.
That's why I was getting turned around too.
Got it. I could have done that first.
Yeah.
Yeah. Sorry, mine was maybe a little out of order. It doesn't really matter. I actually spotted it with you, so I'm
Yeah.
having the same feedback for myself, but it doesn't matter what organization the fact is in. But yes, I agree, should go in order. Okay, so heading would be,
Sue's accusation.
or Sue's statement
Yeah.
accusing Pam of taking the money. Oh. Okay, so what do we have here?
We're jumping back into hearsay.
Well, is this hearsay?
So I do rule for hearsay and then argue first that it's not and then second if
How is this hearsay?
well, if it's being offered for the truth of the matter asserted, then it would be hearsay.
What
right?
is it being offered for?
Well, I think you can use it in two out. It can be used for effect on the listener, so it's not for the truth, or it could be offered for the truth of the matter asserted that she did steal it, in which case I think it would be what's it called? Spontaneous statement.
Let's see. Sue confronted Pam and accused her of taking the money. Pam simply walked away. Where do you get the spontaneous statement here?
Because she testified that she'd caught her stealing it and then confronted her about accusing the money.
But doesn't it have to be at the same time? Contemporaneous?
I don't think it would succeed, but I think it's enough that we could talk about it.
I think it's enough to talk about. I think it's kind of a non-issue.
Okay.
I think this is going to come in for
Effect on the listener.
effect on the listener. Exactly. I think this is a non-hearsay. Now, I like the scope of your issue spotting, Ryan, a lot. And I would say that on the exam, that's going to really have you maximize your points. Because
Really
this is
like
a perfect example of an applicant not going so far outside the scope, but seeing a little bit more that could give you some extra brownie points, okay? So I like it. All right, so it's being offered to show its effect on the listener. Who is the listener?
Pam?
Pam, okay? And therefore, is it admissible non-hearsay?
Yeah.
So we had 3 levels there. That was tricky. Raise your hand if you felt like that was tricky. Yeah, that's why we do this kind of stuff in these Zooms, because I want to point out what the structure of that would have looked like, okay? All right, I am going to speed this up a little bit. I will take on the rest. So we have 3A, David's testimony. About what Pam said to Mike. Gotta cut my nails. Okay. Don't leave me. Don't leave me. Isn't there a song like that? What song am I thinking about? Okay, whatever. All right. Is it everyone participate together? Is it logically relevant? What happened? Are they having an affair? What's it related to? Whether Pam was having an affair with Mike? The key subject of the defamation action? Yes? Everyone say yes? Yes. Okay, so logically relevant. Legally relevant? Probative value as to what? Whether Pam is having an affair with Mike? Same thing?
Yes.
Yeah.
Okay. Is everybody with me? Okay. Where do we go? Do we have public policy? No. Do we need to go into reliability? Okay, what's the key threshold here?
Full testimony.
What is it? Anyone? Just blurt it out.
Personal knowledge.
Knowledge.
Authentication of voice.
Why are we going into personal knowledge? Yeah, voice authentication.
Hmm.
Is David familiar with Pam's voice?
Yeah.
Okay, is this character? Don't leave me. Is it character? Yes or no?
No.
Good, no. Is it coming in to impeach? Is it privileged? Is it hearsay?
Yeah.
Yes.
Okay. Are there exceptions or exemptions?
No.
Think again.
Cited utterance?
Okay.
Oh,
Is it an excited utterance? Is it made under the stress or excitement of the condition or event?
Yes. She's crying, maybe.
Please don't leave me. Yes. God, please don't ever say that to anybody. If anyone's leaving, just say, baby, bye, bye, bye.
Is it Shana, how important is it to call it a spontaneous statement versus an excited utterance in California?
I think you'd get credit either way.
Okay.
I would call it by, you're right, it's correct. Okay, we have admission by party opponent. I can see, which is typical, that a lot of you need to work on these non-hearsay exemption exceptions, okay? And that's totally normal. After law school, we kind of block them out, all right? And we just got to go back and revisit the standard. Just want to, I think we're set. Hold on a second.
Shana, what do you think about
Wait, just
effect
hold on
the
one
listener?
moment. just hold on one moment, please, okay?
Okay,
I'm
sorry.
going to, that's okay, I'm gonna try and. Hmm. Huh. Hold on. Aha. Trying to see if I can extend the time. I didn't think it was gonna take this long to do this thing. Okay. All right, listen, if it stops at, oh, it's letting me open it up. Hold on. I learned how to do this over the weekend, that I can extend if we need to go over. Here we go. Let me just extend it. So as I'm doing that, hold on. Here we go. Oh, okay. All right, let's just finish this up. So admission by party opponent, statement offered against the party, yes, the statement is made by Pam. It's being used against her, so it is admissible there, okay? So here, it's admissible under both exceptions. All right, 3B. So I think I just extended the Zoom in the event that it shuts, it's set to go for 2 hours. In the event it shuts down, I'm gonna restart it so we can finish this up, okay, and just rejoin. David's testimony about what Mike said to Pam. Logically relevant? Yes or no?
Yes.
Okay. What is it related to? Pam having an affair, a key subject of the defamation action. Legally relevant?
Yes.
Same as above, right? Same analysis. This is where you'll start seeing the answers getting like, God, this is a very long essay. Very long, right? I mean, the issue spotting, this is why it's got to be practiced. Okay, where's our reliability standard?
Oral authentication.
Is David presumably familiar with Mike's voice?
Yeah.
Okay. All right, is his character privileged, impeachment, hearsay?
Hearsay.
Yeah. What is the truth of the matter asserted?
That the affair was in fact over.
Well, what Mike said to Pam, or that they had an affair. But yeah, both. Okay, any exceptions here?
No.
You brought it up before, Ryan.
Well, yeah, you can bring them up, but I don't think they're gonna work. Spontaneous statement in the same vein, but fails because he's not under the condition. And then you might want to bring up
Whoa, wait. Forget about the spontaneous statement. There's a really relevant exception here.
It has to do with motive or state of mind, maybe.
I was thinking present sense.
Yes, thank you. That's what I was thinking that too.
Present state of mind. What's the standard
Present
there?
sense. Okay, was state of mind or present sense impression?
Present state of mind. What's the-
The standard is a present mental, emotional, physical sensation or
Mhm.
condition.
Why would that apply here?
It also has to be directly at issue,
Okay,
but
could it go towards David's intent to end the affair?
oh, I was gonna say I wasn't sure what the intent would be, but yeah, that actually does make sense.
Okay, so this is at issue.
do we have to talk about Hillman if we're doing the intent to end?
Do we have to talk about what?
Hillman doctrine?
No.
Okay.
Okay. You will not.
What about the present sense impression that he's saying this while he's perceiving or immediate, like while he's doing it, ending it?
Let's go back to his statement here.
Our affair is over.
Our
You
affair is
need-
over. You need to get on with your life. What is the standard for present sense impression?
Why statement made while perceiving an event or immediately thereafter. In California, it's made to explain conduct while engaging in it. So conduct.
He wasn't
is-
having
Okay.
an affair at that moment. I would say no, not at issue. There's a main one though.
Against interest.
Made by an unavailable declarant against his interest at the time made. He knew it was against his interest. In California, it can be against a person's penal, financial, or social interest. Declarant can be unavailable due to death. Here, Mike died unavailable. Statement by Mike against his social interest or our affair is over. That was my analysis. So yes, admissible under this exception.
So it's against his interest because he's saying that they were having this affair. Is that the idea? I missed.
Correct.
Okay.
Against his, which part? It's against his social interest.
Because he's the president and he shouldn't be having an affair with
Yeah.
an employee. Got
Yeah,
it. Okay.
yeah. That's that lawyer cap, right? It's like it's going outside the scope of it just being an exception where you're like, this is the argument we're gonna make. This is where like in court, you're going ding, 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 this is my exception, right? This is how we're bringing this in. Okay. Is this a dying declaration?
No.
No.
No. Models had it, so it's here. Minor issue, not, if you missed it, that's okay. Not really an issue. We talked about excited utterance, no. Is this an excited utterance?
Mhm.
No,
What's the key fact that says it's not?
So it's
calm, right?
He respond, I think it said
Measured tone.
measured tone, yeah,
Measured
measured tone. Yeah, so it's not an excited utterance. Just putting it in case anyone had it to know that it's not at issue. Talked about the present state of mind. Okay, we're done here. Conclusion is admissible as a declaration against interest or present state of mind. I'm being very to the point. Declaration against interest, okay? Do we have any other, have we hit all the statements? Every part of the statement? Is there anything else? Let's just go back for David. He says, our affair is over. You need to get on with your life. Let me see how I label this. So all of this. Okay. What about you need to get on with your life? If you didn't break this up, it's not going to break your essay. Okay. I'm being extremely thorough right now, really hitting every part of the admissibility for every single statement, dividing them up, pursuant to what the standard is. This is what the state bar wants with both models. Okay. So, what could that come in as? You need to get on with your life.
The effect on the listener.
Effect on the listener. Right. Who is the listener? Yeah. Okay,